Good morning, friends. We'll talk about the Indian Contract Act 1872. You see, the importance of commercial transactions is growing. Trading in goods and services is increasing, and therefore it was thought that let us enact a law which regulates the conduct of the parties to the contract. The law which we are about to discuss establishes the freedom of parties to enter into contracts. To understand the law, we need to understand certain basic meanings which are there in the law. For example, the first important word which you find in this act is contract. Contract is any agreement which is enforceable by law between the parties. It has been defined in section 2H of Indian Contract Act. That is, any agreement between the parties which is enforceable by law becomes a contract. And to understand the meaning of this term, we need to know the meaning of the term agreement. Agreement is reciprocal promise between parties. An accepted proposal becomes an agreement. Thus, the explanations make it very clear that agreement is a wider term as compared to contract, and therefore every contract is agreement, but every agreement is not a contract. We will discuss as to what are those situations in which an agreement gets converted into a contract. An agreement which is not enforceable by law is a void agreement. Specific instances can be found in sections 24 to 30 of the Indian Contract Act 1872. Specific examples can be an agreement in restraint of marriage, an agreement in restraint of legal proceedings, an agreement in restraint of trade, etc. are the agreements which are void. And any contract which ceases to be enforceable by law is a nullity, as if it has never existed, it never came into existence. Such a contract is a void contract. The next important word is voidable agreement. An agreement which is enforceable by law at the option of one or more parties, but not at the option of other parties, is a voidable agreement or voidable contract. The meaning is very simple, that as long as it is not repudiated, it remains a valid contract. Now, as I said, all the contracts are agreements, but all the agreements are not contract. I said we will talk about those instances where an agreement becomes a contract. Now, let us see what are the essentials of a valid contract. To create a valid contract, we need to have a valid offer and a valid acceptance. We need to have consent between the parties. We need to have parties intending to create legal relationship. Parties must be competent to enter into contract. The agreement must be based on free consent of the parties. The consideration involved in the contract must be lawful, and the object of the contract must be lawful. Mind, it must not be violative of public policy. The agreement must not be declared void by any other law for the time being in force, and if there are procedural requirements, then the same must be complied by the parties. For example, the discussion for the requirements related to registration or requirements related to stamp, etc., must be complied by the parties. So we have identified certain ingredients of a valid contract. I will elaborate some of these. The first one, if you recall, was a valid offer. An offer has been defined in section 2A. It is an expression of willingness to do or refrain from doing something. An offer can be made by a natural person, can be made by an artificial person. Natural person means an individual, artificial can be a company, etc. An important thing is it is made to other person with a view to seek his or her assent. Offer can be specific if it is made to a particular individual or a group of individuals. Offer can be general if it is made to public at large. It can be express, it can be implied by conduct. For example, if I go to a self-service counter and I take my food, it is an offer by conduct. It must be communicated to the parties whose assent is required. It can be conditional, it can be unconditional. Thus, it is an expression of willingness to do or refrain from doing an act. It is important to distinguish offer from invitation to offer. As I said, offer is the final expression of willingness, whereas an invitation to offer, the person proposes certain terms around which he wants to negotiate. An example of invitation to offer is proposed auction sale, where I am not giving you offer to be accepted, I am inviting the proposed bidders to present their offers. Another example can be, there may be a shelf containing books with price tags attached to it. This is not an offer to sell the books on the price which is mentioned in those books. In fact, it is an invitation to all the proposed purchasers to present their offers. So this distinction has to be kept in mind. Offer is different from invitation to offer. The second important ingredient of a valid contract is a valid acceptance. You see, a proposal is said to be accepted when the person to whom it is made signifies his assent to the offer. It is defined in section 2B of the Act. There are certain prerequisites of a valid acceptance. That is, it must be given by the person to whom the offer has been made. It must be made within reasonable time. It must be absolute and unconditional, unqualified. It must be communicated to the offerer who has presented the offer to me. It must be communicated to the offerer in a manner as contained in the offer, or it can be communicated in any customary manner. It is important to note that cross offers do not constitute a valid contract. For example, I said that I want to sell my blue pen, and you also at the same time said that you want to purchase my blue pen. These are cross offers. These two put together cannot create a contract. Plus, an important point is, an offerer cannot impose upon the offeree a duty to reply. For example, he cannot say that if I do not get any reply within 15 days, it is deemed to have been accepted. Such a compulsion cannot be there in offer and acceptance. Mind, once rejected, an offer cannot be accepted. It is important to know the place of contract, which largely depends on the place where acceptance is said to have been done. If the acceptance is communicated by way of letters, then the place where the letter of acceptance is put into post happens to be the place of contract. And in case the acceptance is communicated by telephonic conversation, then the place where the acceptance is heard becomes the place of contract. It is important to decide place of contract, because only then we will be able to decide as to which court has got jurisdiction to try matters arising out of this contract. The third important ingredient of a valid contract, if you recall, is capacity to contract. Under the Indian Contract Act 1872, all persons are competent to enter into contract except minors and persons of unsound mind and a person disqualified by any law. A person is of unsound mind according to the law if he is unable to understand the content of the contract at the time when the contract is being made, or if he is unable to understand the implications of the contract on his interests. Second point I said is, a minor's contract is void. Now this is void because we wanted to protect the interest of minors. However, parents of minor can enter into a valid contract. There is a small list of certain people who are debarred by law for the purpose of entering into contract. Now other disqualified persons can be alien enemy. Alien enemy means a citizen of a country with which we are in the state of war, and such contracts require permission of government for the purpose of execution, enforcement. Second is foreign diplomats. One cannot enter into a valid contract with foreign diplomats. Third is person with conviction. You cannot enter into a contract with person who is serving a sentence. An insolvent person, as long as the proceeding of insolvency is going on in a court. And certain corporate bodies, depending on the nature of contract and the powers or responsibilities which that corporate body may derive out of the statute under which it has been made. The next important ingredient of a valid contract is consent of the parties. Consent of the parties can be understood with the help of a maxim called consensus ad idem, which means agreeing on the same thing in the same sense. That means I want to sell my blue pen to you, you want to purchase my blue pen. So therefore we agree on the same thing in the same sense. It is important to know that mere consent is not enough. The consent must be free consent. That is, it must not be obtained by coercion, fraud, undue influence and misrepresentation. If it is obtained by any one of these, that is coercion, undue influence, fraud or misrepresentation, it becomes voidable at the instance of the person whose consent has been so obtained. Whereas, if it is obtained by mistake, then the contract becomes void. Mistake of fact, contract becomes void. So, kindly note that consent has to be free consent. The meaning of these words can be found in sections 14 to 22 of Indian Contract Act. The next important word in Indian Contract Act is consideration, where at the desire of promisor, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or abstains from doing any act, then such act or abstinence is called consideration. So kindly note that consideration in Indian law is not only the money, it is any act or any abstinence. It can be past, it can be present, it can be future. A doctrine related to consideration is called doctrine of privity of contract, which says that a third party cannot sue for performance or enforcement of the contract, although the contract may have been made for the benefit of that third party. Indian contract law does not only deal with relationships arising out of contract, it also deals with certain quasi-contract situations. That means the relationships which are akin to contractual relationship, but these do not arise out of contract. Here, the obligation to pay does not arise out of any contract, it arises out of a fact that somebody has benefited from others' cost. That is a situation of unjust enrichment. For example, if I have sold certain goods to you and instead of delivering it to you, wrongly deliver it to a third person, and that third person starts using those goods, then the third person is responsible for sale consideration of goods to me. So that is the situation where the third person is getting unjust enrichment at our cost. There is no contract between me and the third person, there is no contract between you and the third person, but still the law of contract will ensure that such relationships are regulated under the Contract Act. The next point is discharge of contract. A contract can be validly discharged by performance. It can be validly discharged if two parties agree mutually that let's put an end to the contract. It is discharged by lapse of time provided in the contract. It can be discharged by occurrence of any event which makes the performance of contract impossible. Breach is also a way of discharging, but breach of the term of contract will entail consequences. In case somebody is committing breach of contract, the other party has the remedy in the form of suit for cancellation of contract. He can file a suit for damages. He can file a suit for money to the extent of work completed. He can file a suit for specific performance, and he can file a suit for injunction. You see, apart from general principles of contract, the Indian Contract Act also regulates relationship of parties in relation to certain specific contracts. Some of these specific contracts include, first, indemnity. Indemnity is a contract by which one party promises to save the other party from the loss caused by him by conduct of promisor or any other person. That means A contracts to B against the consequences of any proceeding which C may take against B in respect of certain sum of money. This is a contract of indemnity. The next special contract is guarantee. It is a contract to perform the liability of third person in case of default. So therefore, a guarantee will always involve three parties, the debtor, the creditor and the guarantor. Any transaction which one comes across when he goes to a bank for the purpose of obtaining loan can be an illustration of guarantee, where a third party is involved in the transaction and asked to sign certain documents where the third party becomes the guarantor. The next is contingent contract. The example is all the insurance contracts. It is a contract to do or not to do something in event of occurrence of certain unforeseen future events. And as I said, all the contracts relating to insurance are the example. The next example of special contract is bailment. It is delivery of goods by one person, that is bailer, to the bailee for some purpose upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to direction of the person delivering them. There are clearly identified duties of bailees and bailer. A bailee has to take care of goods. He cannot make unauthorized use of goods. He should not mix goods with his own goods, and he must return the goods when the task is or the purpose is accomplished. Whereas the bailer is under a duty to reveal all the facts about the goods. He must pay charges. He must pay charges for the special nature of the goods. He must indemnify the bailee for any loss, and he must receive back the goods. Mind, if the control of owner is maintained, it is not a case of bailment. The last one is pledge. If the bailment is done for the purpose of payment of any debt, or if it is done for the purpose of performance of any contract, such a bailment is called pledge. Here the bailer is called pawner and the bailee is called pawnee. So I believe this discussion is sufficient to understand basic things about Indian contract law, and to understand it more, kindly refer to our Manage website, or you can also refer to the documents or the study material supplied by the Manage to you. Thank you very much.